Today, I'm going to walk you through wraparound mortgages, sometimes just called a wrap, and how they work here in Texas. I'll explain the mechanics, the benefits, the real risk, and the legal rules you absolutely need to understand before you try one. This is creative real estate financing. It can be powerful, but only if you follow the rules. Let's start with the basic problem. Sometimes the bank says no. You've got a buyer who has cash for a down payment, but maybe their credit isn't perfect. Maybe they're self employed. Maybe their income doesn't fit neatly into a traditional underwriting box. Getting a bank loan can be hard. On the other side, you have a seller who wants to sell the house for a fair price, but they still owe money to their original lender. They can't just ignore that loan. So, what's the solution? In a wraparound transaction, the seller becomes a lender. That's the core concept. Now, let's break down how that actually works. Think of a wraparound mortgage like a big box. Inside that big box is a seller's existing loan. Let's say the seller still owes $100,000 to their bank. Instead of paying that off, the seller keeps that original loan in place. That's often called the wrapped note. Then the buyer signs a new, larger loan with the seller. Maybe that new loan is for $150,000. That new loan wraps around the old one. So now the buyer owes the seller under the new wrapped note, and the seller still owes the bank under the original loan. This is a form of seller financing. The bank is not issuing a new loan, the seller is. So, how does that money actually move each month? Let's follow the payment. The the buyer makes one total monthly payment to the seller. Let's say it's $1,500. The seller then takes that money and pays the old bank loan. Maybe the payment to the bank is $1,000. The remaining $500 is the seller's profit or spread. The key thing to understand is this: the seller collects the money and is responsible for paying the old bank. Now, here's something that surprises a lot of people. In a wrap transaction, you actually own the house. At closing, you receive a warranty deed. This is not a lease. This is not rent to own. This is not an installment contract in the old fashioned sense. It's a sale. You get immediate ownership. But, and this is critical, the property is still tied to the seller's old bank loan. We call this subject to the existing lien. The debt is still attached to the property. And this is different from formally assuming the loan. In a wrap, the seller remains legally responsible for the original bank. The buyer is not stepping into the seller's shoes with that lender. That legal structure is what makes wraps possible, but it's also what creates risk. So, why would someone choose a wrap? From the buyer's perspective, speed is a big factor. There's no long wait for bank approval. You can close faster. Access is another reason. Buyers with less than perfect credit may be able to buy a home they otherwise couldn't. And because it's a true sale with the deed, you may receive immediate tax benefits associated with the ownership. From the seller's perspective, wraps can allow them to sell at a higher price. That can earn monthly cash flow from the spread between what the buyer pays and what they owe the bank. And it can help sell a hard to move home, especially in slower markets. But now we need to talk about the elephant in the room, and that's the due on sale clause. Most bank loans have a rule that says that if you sell the house, the loan must be paid off immediately. In a wrap transaction, technically, the bank has a right to call the note. That means they can demand full payment right away. Now, here's the reality. Banks usually don't act as long as payments are being made on time, but they absolutely can. So, what's the practical solution? Buyers need to be prepared. If the old bank calls the note, the buyer may need to refinance and pay off the underlying loan. That's not a theoretical risk, it's a real one. There's another trap I see people miss in insurance. Sometimes sellers want to cancel their old insurance policy to save money. That's a huge mistake. If the old bank sees that their required insurance has been canceled, they may panic and move toward foreclosure. The proper way to handle this is to have double coverage. The original insurance policy stays in place to keep the old bank satisfied, and at the same time, the buyer buys a new policy to protect their ownership and personal property. Yes, it costs more, but it's necessary for safety. Now, let's talk about Texas specific rules. Texas law requires very specific disclosures in wrap transactions. There is a mandatory 7-day warning period before closing. The seller must give the buyer a list of all existing loans on the property at least 7 days before closing. And that notice must clearly warn the buyer about the due on sale risk and the insurance issues we just talked about. If the buyer does not receive that notice at least 7 days before closing, the buyer has a right to cancel the deal and get their earnest money back. That's not optional. That's Texas law. Next, protecting your money. Under Texas law, the seller holds the buyer's payment in trust. That means they have a fiduciary duty to use that money to pay the old bank first. If the seller stops paying the old bank, the buyer has the right to step in and pay the bank directly. And if the buyer does that, they can deduct that amount from what they owe the seller. That's a powerful protection, but only if the documents are drafted correctly. And that really leads me to my next point. Do not try to do this alone. Wrap transactions require a team. You need a lawyer who drafts a custom wrap addendum. Standard contract forms are not enough for these complex deals. Texas law also requires that the deal close at a title company or an attorney's office to be valid. You cannot do this at the kitchen table. And sellers also have to have the responsibility under federal law. They must check the buyer's ability to repay, including income and credit, to comply with any federal lending regulations. Finally, let me give you a simple checklist for a safe wrap. You need to confirm the math, make sure the new wrap loan truly covers the old loan, and puts a price in terms you can agree to with all the parties. Review the 7-day disclosure notice carefully. Secure proper insurance, both the old policy and the new one. Use professionals to draft the documents and close correctly at a title company. Wraparound mortgages can be powerful tools. They allow flexibility. They create opportunities. And in the right situation, they can benefit both buyer and seller. But they are not casual transactions. If you're considering a wrap in Texas, make sure you understand the risk, the disclosures, and the legal requirements. I'm a Texas real estate attorney, and I've seen these done well. I've also seen them go wrong. If you found this helpful, subscribe to the channel. I post regular content breaking down real estate law in plain English, so you can make smart decisions moving forward. And if you're thinking about structuring a wrap transaction, talk to a qualified Texas real estate attorney before you sign anything. Appreciate you coming by. Subscribe and like, and I'll see you in the next video.